So good evening, everyone. On behalf of the FIT Library, I'm Professor N.J. Burdine, the Library Director, and our Associate Director, Greta K. Ernest, really want to welcome you to FIT along with the administration of FIT, State University of New York. Tonight's event here in Katie Murphy, The Past, the Present, and Future of American Free Speech, brings to you two great authors and a moderator. Authors Amy Werbel, who wrote Lust on Trial, and Nadine Strossen, Hate, is reflecting on what past American experience suggests about the future of free speech in our nation. And we're fortunate enough to have our moderator, Professor Daniel Levinson-Wilk, who's going to be moderating this discussion. I want to thank the panelists and moderator for giving their time and talent for tonight's event. I also want to give a big thanks out to Jane Mahoney from the library, who has coordinated this event and many other events in our Love Your Library series. In addition to that, I want to mention that the FIT Faculty Senate Library Committee is also promoting FIT authors on campus. And we're going to be hosting information about those authors on our website. There's a brochure there's a display in the FIT library. So please look forward to getting more information as we're going to be promoting faculty scholarship here at our campus. But let me give you some introductions about our panelists. And I'm going to start with Professor Nadine Strossen, who's the John Marshall Harlan II Professor of Law at New York Law School. She's written, taught, and advocated extensively in the areas of constitutional law and civil liberties, including through frequent media interviews. From 1991 through 2008, she served as the president of the American Civil Liberties Union, the first woman to head the nation's largest and oldest civil liberties organization. Professor Strossen is currently a member of ACLU's National Advisory Council, as well as the advisory boards of the Electronic Privacy Information Center, Foundation for Individual Rights and Education, and the Heterodox Academy. Her book, Hate, Why We Should Resist It with Free Speech, Not Censorship, was published by Oxford University Press in May of 2018. University of Chicago law professor Jeffrey Stone, a noted First Amendment expert, wrote in his foreword to the book that Strossen stakes out a bold and important claim about how best to protect both equality and freedom. No one can address this issue in the foreseeable future without taking on this formidable and compelling analysis. It lays the foundation for all debates on this issue for years to come. In 2017, the American Bar Association presented Professor Strossen with the Margaret Brent Women Lawyers of Achievement Award. The National Law Journal has named her one of the 100 most influential lawyers in America. Vanity Fair included her in America's 200 most influential women. Ladies' Home Journal named her among America's 100 most important women. And Working Woman magazine listed her among 350 women who changed the world. And Upside magazine included her in the Elite 100 executives leading the digital revolution. In 2005, she was honored by the University of Tulsa College of Law and the Tulsa Law Review, which made her scholarly work the subject of its 5th annual legal scholarship symposium entitled The Nadine Strossen Scholar as Activist. So please join me in welcoming Nadine. Our second panelist, our very own Professor Amy Werbel, who is an associate professor of the history of art at FIT. She's a graduate of Harvard and Radcliffe Colleges and Yale University. Her scholarship examines the relationship between censorship and cultural expression, focusing on the United States before World War I, and the lessons this period holds for our current moment. Her most recent book is Lust on Trial: American Art, Law, and Culture During the Reign of Anthony Comstock, which was published by Columbia University Press in spring 2018. She has published numerous works on the subject of American visual culture and sexuality, including Thomas Aiken's Art, Medicine, and the Sexuality in 19th Century Philadelphia, and is the recipient of fellowships and scholarships from a variety of institutions, including the Frick Center for the History of Collecting, the Smithsonian American Art Museum, the Gilder Lehrman Institute of American History, and the Metropolitan Museum of Art. From 2011 to 2012, Amy served as a Fulbright Scholar in China, where she taught American Studies and Art History courses to graduate and undergraduate students and lectured throughout the mainland on topics including censorship. In addition, her self-published book, Lessons from China, America in the Hearts and Minds of the World's Most Important Rising Generation 2013, reflects on these cross-cultural experiences. So please join me in welcoming Amy. And last but not least is our moderator, Professor Daniel Levinson Wilk, a professor of American history here at FIT. Daniel is a graduate of Amherst College and Duke University. He's also received the SUNY Chancellor's Award for Excellence in Teaching in 2011. Dr. Levinson Wilk writes about modern service sector in 19th and 20th century U.S. history. He argues that places like restaurants, hotels, barbershops, and apartment houses displaced slavery and servitude by offering consumers a better product outside the home. His work examines the role of trust in the American economy, historical uses of the sociological term emotional labor, the intersection of design and labor in service workplaces, and race and gender typing in service jobs, and the ethics of tipping. He recently, with Dr. Kung Yi Poon, won a $100,000 grant from the National Endowment for the Humanities to develop new curriculum to teach art and design students the business and labor histories of the careers they plan to enter. He has also written extensively on the history of elevators and is an occasional contributor to the trade journal Elevator World and has been quoted on the subject in the New York Times, the Boston Globe, and the New Yorker. Until its recent demise, he was the associate director of the Elevator Historical Society, the only brick-and-mortar museum of elevators in the world. And in addition, along with all of these things, he is the political action coordinator for the United College Employees of FIT here at the college. So I'm going to turn this over to Dan, who will lead us through, I think, a very interesting, provocative, and wonderful program.
Thank you, NJ. Thank you all very much. Thank you all for being here. Thanks, NJ. Thanks, Jane, so much for putting all this together. I have some questions for our wonderful panelists, but I wanted to start out with an unprepared question. This is sort of a Supreme Court nerd question. Who's your favorite John Marshall Harlan?
Oh, the second, I have to say. And the first was there were two of them.
There were.
Yeah, John Marshall Harlan was really a formidable character. Among other things, he was the sole dissenter in Plessy versus Ferguson, the notorious 1896 case in which the Supreme Court upheld the pernicious doctrine of separate but equal as supposedly not violating the equal protection guarantee, which had been added to the Constitution after the Civil War. And he was remarkably committed to equal justice for everybody, regardless of race, color, and so forth, remarkably ahead of his time. For our own ears, some of what he says is archaic and bothersome, but I think it's really because he's definitely, and this was true for Abraham Lincoln himself, right, by our own standards, not as accepting of equality. But I always tell my students that we have to have historical humility, and I'm sure a future generation will look back on us and see that we had blind spots. And somebody said, I don't know who said it, that we should judge our predecessors not by their blind spots, but by their vision. And certainly John Marshall Harlan, the first vision, was wonderful and inspiring. John Marshall Harlan II, even more so, but that's more than enough for Supreme Court nerd.
Okay, thank you. Let's talk a little bit first about the history of freedom of speech in America. Where does the tradition of American free speech come from? And Amy, do you want to answer that first?
Yeah, my book considers the more historical period. And one thing, as a history of art professor, I would just like to say that I got started on this because I was studying the artist Thomas Eakins, and he was censored. His artwork was sort of banned from certain exhibitions. He got fired from his job. And the name Anthony Comstock came up in Board of Trustee minutes as to why they had to fire him because they were afraid of Anthony Comstock. And I had no idea who that was, which led to a 10-year-long journey of sort of getting, as I said, sucked into legal history in order to understand the larger context. So among the many things that I learned is that we were initially 13 colonies, 13 out of 26 English colonies. And the various colonies operated under English common law. And common law was a tradition that involved trial by jury. That was one of the big emphases, and a reliance on judicial decisions. And I told Nadine to please correct me if I'm getting any of this wrong. So when the colonies became states, the tradition of English common law was adopted by the states with the provision that they would go on to make their own laws. So we have something that England didn't have, which you may recognize up there. We have the First Amendment. We got the Bill of Rights. That wasn't in English common law, and really that came out of a very particularly American tradition of dissent. And I think when I read the Bill of Rights, often it reads to me like all of the things the revolutionaries were angry about that the English crown had kind of forced upon them, and at this moment, at the height of the Enlightenment, when they really are imagining in very kind of idealistic terms the potential for government of the people, by the people, for the people, they created a body of rights that on paper went well beyond the rights that people had through the tradition of English common law. One of the things that really fascinated me about that tradition was that you had the crime of blasphemy against the king or the queen, which could be political or could be sexual speech, because the king or queen was the head of both church and state. So you have this idea of like theocracy that is flowing through the tradition of English common law. And then we have an American government that is very specifically and purposefully created without reference to any faith tradition. So that's part of the history that I really go through in my book, is following the career of Anthony Comstock, who's an evangelical born in New Canaan, Connecticut, and he attempts to really impose a faith-based censorship on this very freewheeling, libertarian American culture, and it really doesn't go very well. And so part of what I was looking at when you think about what's the free speech tradition, there's the letter of the law, and then there are the rights that people believe they have and that they act upon. And what I'm really interested in is that symbiotic relationship between the way we, the people, force change in the law, and eventually over time, that meant forcing a recognition that, hey, the language of the First Amendment should apply to political speech and should apply to sexual speech. And then, so the law changes, and then as the law changes, culture changes as well, and these things kind of evolve together. And so that's basically, hopefully, a kind of a nutshell.
That's so interesting, and I really agree with Amy's observation that the law and the culture are mutually reinforcing, because the First Amendment itself, for two reasons. Number one, the First Amendment is written in such open textured language that doesn't answer specific controversial questions. It says Congress shall make no law abridging the freedom of speech. Well, what is a law? What is freedom? What is an abridgment? What is speech? People have actually even argued and litigated over the word "the" in that clause. Antonin Scalia famously, given his adherence to textualism and originalism as the touchstone for interpreting the Constitution, said the use of the definite article "the" means that the framers had in mind a particular conception of the freedom of speech, and he tried to anchor it to what existed at that time, the narrow common law version that Amy outlined. So, and then the second way in which the culture and the law are interrelated was well summed up by the first serious free speech scholar in this country, Zechariah Chafee, who was a professor at Harvard Law School. And in the first half of the 20th century, he wrote the first serious treatise about First Amendment law. And even though he was an expert on the law, he said, in the long run, people will have as much freedom of speech as they want. And it's very important for us to remember that now when we have a Supreme Court that is not going to be friendly to a lot of issues of individual rights, although perhaps more friendly on free speech than on some other rights. That what was meant was that we, the people, as the ultimate governors, will elect presidents and members of the Senate who in turn decide who is going to have the power as justices and judges to interpret the First Amendment. And for most of our history, the Supreme Court had an extremely narrow interpretation of the First Amendment. So the rights that I cherish and that anybody who is advocating for any kind of law reform or social change or dissenting from government policies or criticizing government officials, our version of First Amendment freedoms really only were recognized by the Supreme Court starting in the second half of the 20th century. So in the first part of the Martin Luther King wrote his historic letter from a Birmingham jail for expression that today would be protected. Margaret Sanger and Emma Goldman, pioneering leaders of the reproductive freedom movement, were imprisoned because they simply gave women information about their bodies. The ACLU was founded in large part to defend freedoms that were violated in droves at the time, including First Amendment freedoms. This is almost 100 years ago. During the World War I era, 15,000 people were imprisoned merely for peacefully criticizing the war, including members of the clergy who said that the war was antithetical to Christian values. So the rights have existed in theory for much more of our history than they have existed in actuality.
Nadine, I was wondering if you could talk a little bit more about what you think are the important legal precedents that have limited freedom of speech over the 20th century in particular.
Or the opposite.
Well, I'm interested in limits, but you can do both.
Okay, so let me start with the positive, as that's my my orientation as an activist. I always see the glass half full. So starting in and it's really no coincidence that most of the landmark free speech decisions that so many of us now take for granted were forged in the cauldron of the 1960s civil rights movement. We had a Supreme Court then, the Warren Court, that was very sympathetic to the civil rights movement and understood that censorship was a major tool that was being used to suppress their activism. So partly in the service of freeing up these advocates of racial justice, the Supreme Court opened up freedom of speech for all of us. Conversely, before that, we had a court that was deeply hostile to any kind of protest movement. It was, I have to say this, I don't know anybody who would disagree, including conservatives, that the Supreme Court that we have now is probably the closest to what we had before the Warren Court. It may even be more conservative in the sense of maximizing government power over individuals, so that previous conservative court used its power to uphold suppression of any expression whose viewpoint was considered to possibly, potentially, indirectly, at some future point, might bring about some harmful impact. Well, think about it. I think that's almost 100% of all speech, if not 100%. In a dissent in one of those early cases, Oliver Wendell Holmes said, every idea is an incitement. And by that, he certainly did not mean, therefore, every idea can be censored, but exactly the opposite, the fact that it might incite to some negative action at some point in the future could not possibly be a justification for punishing it, but it was, and those who were simply seeking to advocate for unpopular positions were actually imprisoned.
Thank you. I want to ask a little bit more about the sort of nuts and bolts of censoring in the past. Can you tell us a little bit more about how a censor made a living in the late 1800s and the early 1900s, and how anti-censorship activists would make a living?
Okay, so I'm going to take you back to the dark ages of American censorship. In the very early years, there really wasn't a huge amount of government censorship. As I said, after the Bill of Rights was passed, Americans were really kind of, I think, very cognizant that they had a right to dissent that was different than the English law they had come from. There weren't a lot of censorship cases brought, especially because the one really big sort of action by President John Adams, the Alien and Sedition Acts, went horribly wrong, and his party got thrown out of office. And he had tried to institute limits on immigrants' voting rights and on political speech. And as I said, people reacted really badly to it. So as of 1802, there's this relative lull in government censorship. Anthony Comstock, as I mentioned, came from a very puritanical evangelical family in New Canaan, Connecticut. And right from a very early age, he was devoted to sort of cleaning up sin. And he referred to himself as a soldier of the cross. So he was really like Jesus' policeman on earth. And this was, he goes and fights in the Civil War. And after that period of time, a lot of the evangelicals who had been distributing Bibles in the Civil War, when the war was over, they turned their attention and their very formidable resources to suppressing vice. And this started in New York, but then it spread really throughout the country. So they formed this organization, the New York Society for the Suppression of Vice, and you can see pretty clearly in the insignia what they did, which is they found smut, they burned smut, and they put people in jail. And I do think it's very important to understand, going back to that idea of theocracy, that the Comstock Law, which was the first federal law to ban birth control, abortifacients, an enormous number of things that could be deemed obscene, with a mechanism for enforcement. This was an amendment to the Postal Code, so now there were going to be postal inspectors who had authority to direct federal arrests or indictments, to bring indictments under federal law for circulating these materials. That law was actually written in part with the help of a Supreme Court justice named William Strong, who was at the same time also trying to get a constitutional amendment to insert Jesus into the preamble. So when we think about Supreme Court sort of gone awry, this was a private moral reform organization that was had branched out from the Young Men's Christian Association. They were evangelicals, and they were lobbying in Washington to pass these laws. So after the Comstock Law was passed, New York State gave the New York Society for the Suppression of Vice some prosecutorial authority, and the day-to-day work was basically Comstock would be on the beat. If he saw something in a shop window, he would go into a saloon. If there was a picture of a woman in tights on the wall, he'd threaten to bring an action, and if they didn't take it down, he actually would arrest them. And then there was a whole spying thing that happened, that people would mail in literature, pictures, they would report on each other, and so then Comstock would investigate. So you had neighbor turning on neighbor, and that was basically the work. And it took a while. In the 1870s, most of the cases got thrown out. And then towards the end of the in 1878, they start to have some real success, especially initially with freethinkers, agnostics, people who are preaching that the world is, hundreds of thousands of years old. They don't want the Bible to be the focus of education in public schools, which it was, and they really wanted to promote the rights of atheists and agnostics in society, which Comstock labeled all of that obscenity, going back to this English tradition of blasphemy against the church. So then he had a fair amount of luck and continued to the end of his career in 1915. But my book really follows the trajectory. He gets some power, but then when he actually gets some power and people actually get thrown in jail, Americans start to wake up and say, this doesn't feel like America is supposed to be. And then there's this sort of tipping point, I would say, in the 1890s, where the censorship just starts to produce a lot more backlash than actual suppression of materials. So basically that's, the other, just one more really important thing is that when Comstock gets started, these cases were relatively new. And he would argue that the material was too harmful for the jury to see.
Yeah. Yeah.
So often he burned it before the trial even happened. And then, again, there's a tipping point in the courts. The defense attorneys are basically saying, how can a jury of peers judge the actions of the defendant if they can't actually see what the person was, writing, drawing, printing, whatever. And so by the end of Comstock's career, there's a lot more attention to due process and procedure, and the juries are always looking at sometimes very obscene speech by the end of his career.
Amy is making me realize that when I talked earlier about the strong protection of free speech we've had since the middle of the 20th century, there is one huge exception, and that is that we still have literally an obscenity exception that the Supreme Court has just superimposed onto that unqualified language about the freedom of speech in the First Amendment. And it was justified by Scalia and others as saying, oh, well, the freedom of speech referred to this historical concept. And that's very debatable because the framers, as Justice Douglas said in one of his dissents, were the products of a open-minded, not a prudish age, right? And we didn't have anti-obscenity laws until at either the state or the federal level until much later in our history. But for what it's worth, it is still can be a crime to distribute, to create, distribute, or even just look at any material that is deemed to satisfy the obscenity exception. We're now living at a period in our culture where government, for political reasons, is not making a big crusade about this. Although I did hear that if you look at the Republican Party platform, they did call for stricter enforcement of the anti-obscenity laws, and Jeff Sessions has said that certainly under Attorney General John Ashcroft. That was a huge priority in the Reagan administration under Attorney General Meese with his pornography commission. That was a big issue. So these things come in waves, and again, if there's not much popular pressure to punish sexual expression, it won't be done. But it still would not be unconstitutional to do that. So when you were talking about the ignorance of the jury not even being able to see the allegedly illegal materials, I remembered something that's, by my standards, not ancient history. In the 1980s, when we were going through one of these periodic episodes we have in this country of anti-sexual frenzy, including against sexual expression, there was the very first, and I believe so far only, criminal prosecution of an art museum and an art museum director for works of art. And this was the Cincinnati Museum for displaying the Robert Mapplethorpe photographs. And I remember that it was a case that was handled by the ACLU, and the lawyer was a friend of mine who was defending the museum. And he had this brilliant strategy that a lot of people didn't understand at first. He impaneled a jury, not a single one of which, it actually wasn't, sadly, it wasn't that hard to find a jury, not a single member of the jury had ever been to an art museum. And a lot of people thought, uh-oh, this is going to be bad news, but it was a brilliant strategy, because one of the 3 requirements for something to be found constitutionally obscene and hence excluded from the First Amendment, you have to satisfy all 3 requirements, and this one will sound familiar to people, that the material has to lack serious literary, artistic, political, or scientific value. So he brought in a number of art experts who attested to the serious artistic and political value of the allegedly obscene works, and the jurors threw up their hands. They said, we know nothing about art. We've never been to an art museum. So the experts say that it's got value. I guess it has value, and that's how the case was won. But it's shocking to me that we still have this, that art, serious art and other cultural expression, if it deals with sexuality, is still much, much less protected. And that's than what the Supreme Court has called political speech, speech about public issues. It's a completely artificial distinction, because so much art deals with those issues.
Right. And that's one of the things I really thought was very interesting in my book, is where political speech and artistic expression are really on completely separate tracks. Like, the art is prosecuted under obscenity laws, the political speech is much more protected. But then when you've got Emma Goldman and Margaret Sanger, and who are advocating for birth control and the rights of women, and it's all around the time that women are campaigning for the vote, and that's where these trains collide. And sexual speech is political speech. And the forerunners of the ACLU, most notably Clarence Darrow, is defending everyone. He's the first attorney, at least that I've seen in my research, who is defending labor union organizers and people preaching yoga sex, like Ida Craddock, and basically anybody that was being prosecuted for their speech or expression. Clarence Darrow was there, and then of course religious. He's also protecting agnostics and atheists, and so that's where the defense tactics of attorneys, and he's part of the Free Speech League, which eventually kind of turns into the ACLU. So that's a thread that I think is, to me, the pivotal point where the game changes. And you have attorneys start to conceptualize the rights of individuals in a way that, we use the phrase content neutrality now. They didn't use that term, but it really was, they understood that we all have free speech or none of us have free speech. And a lot of these artificial distinctions between types of speech, they're all slippery slopes. And so that's where I feel like the 20th century conception of free speech that's going to evolve is really born in that moment in the Free Speech League, right around the turn of the 20th century.
And I'm going to say something that I'm sure is controversial, exercising my free speech rights, but I continue to fear and observe that our culture is still especially hostile to sexually oriented expression. And there continues to be this odd alliance between the right and the left ends of the political spectrum, each having different reasons for being particularly fearful or suspicious of speech about sex or gender. So from the conservative traditionalist perspective of Anthony Comstock, Ed Meese, John Ashcroft, et cetera, it's the challenge to, quote, traditional family values and traditional religious and moral values. But from the left end of the spectrum, it has been, starting in the late 1970s and through the feminist anti-pornography movement today, carried forward very much, in many cases, arising from the very important concern against sexual violence and sexual harassment, but there are excesses that, in my view, are very serious in terms of serious and important expression, including political expression, about these extremely important issues of sex or gender are too often being lumped together with violence and assault as punishable sexual harassment.
Yeah, I couldn't agree more. And a lot of times I say, look, I am a feminist. If I believed that censorship would help us get rid of sexual harassment and sexual assault and prejudice, I might, be willing to kind of abrade the edges of my free speech activism. But the historical example does not support that whatsoever. And what we see is that at the moments when censorship has been most intense in this country, it supported patriarchy much more than anything else. And the rights of women were eroded, and the rights of women to control their bodies were eroded by having the government determine what speech was allowable and not. And I would just throw out there Stormy Daniels. I mean, when we think about culture, right? I mean, the whole conversation about pornography that could potentially be happening at the sort of Jeff Sessions level would be so completely and utterly hypocritical. And the cultural factors of what's actually going on, that Stormy Daniels has now become a feminist heroine for bringing lawsuits against Donald Trump, is a pretty interesting kind of evolution from the 1970s feminist anti-pornography campaigns. So culture and law, they shape each other, and we are in a moment right now where there's just like so much pasta being thrown against the wall. It's a little bit hard to see, what's going to actually end up really sticking.
So we're in a moment right now where technological change has led to a whole lot of new media. And I think a lot of students today think that that's totally revolutionary. But in fact, we've had technological change leading to new media for hundreds of years. And I was wondering what effect those shifts have on censorship. And we can talk about lithography or photography or movies or any other new media at any given time. What do you think?
Well, I'd love to, because I'm an art historian, I have PowerPoint slides, and I just, hopefully to keep this concise, but the technological changes just really always made it impossible for censors to get ahead of the curve. So they would maybe start to get a handle on the distribution of imported photographs. But then there were cell phones and phonographs, and they might start to get a handle on that, and the producers of cell phones and phonographs, and then there's film. So every iteration of new technology kind of puts the censors back on their heels. And that's exactly the story of technology. And what I observed in my, broad sweep of looking at censorship from really the middle of the 19th century to World War I is that art censorship always, in any media, brought out outright defiance. You'd always have some people who would say, oh, you're going to tell me that I can't make that? Well, that's exactly what I'm going to make. And then subversive shifts in art production, and that is where technology, so if this technology gets censored, then people would shift to a new technology. So it's very hard to actually have effective censorship. I will say, having lived in China, unless you have a completely repressive authoritarian state in which basically there are no free speech rights whatsoever, it is very different. I'm talking about the American history of trying to have censorship in a society in which people are very libertarian, in which we have a strong constitutional right of free expression. So that caveat said, images migrate to new platforms. You see in the 19th century, images go from books to burlesque shows to phonograph recordings to early film. The censored subjects just keep moving because people are titillated by them. And then it makes money. If you produce a titillating work of art that's a little bit over the edge, people will pay more for it. And so the profit motive in America is, never to be forgotten. These are the kind of the early pioneers of representing Comstock's defendants and the defendants of early censorship. But I wanted to just give the example of one of these rulings that was imported from England, the Hicklin test. Material is obscene if it has a, quote, tendency to deprave and corrupt the minds and morals of those who are open to such immoral influences. Well, when people started demanding that Facebook clean up its act, and I have a sense that they know nothing about the history of free speech in the United States, they adopted this language. We restrict the display of nudity or sexual activity because some people in our community may be sensitive to this type of content, right? Totally makes sense, and like the Hicklin test, it's based on harm to anyone who might be harmed, right? They're not defining who that might be.
Subjective.
Right, it's completely subjective. And so, but who's on Facebook? Like everyone, right? It's gone global. So our community, we talk about community standards, hard enough in the United States, but they had right away these protesters in Durban, South Africa, wanted to be able to perform traditional dances from their home culture. These were students who had come to Durban to go to university, and they were uploading their photographs, and Google and Facebook were taking them down, and they had this protest. This was 2017. And so, well, wait a second, in their community, you can see, my culture, my pride. Well, their culture, their pride, like the display of breasts is a form of empowerment, right? So, oops, Facebook is global. Again, how are you going to define a community? And then you also have now Artists Against Social Media Censorship. You have a group of artists who are taking whatever the algorithms are of social media are being created to try to restrict. Like they have algorithms that try to identify a naked breast, for example, like the relationship between the nipple and the curvature of the outer circle of the breast, because they're dealing with so many millions and millions and millions of posts every really hour. So they are playing with the algorithms, and they've sort of banded together and made a new style of basically whatever it is that the algorithms would pick up on. They try to change it up just a little bit and they have very kind of witty and interesting provocations to every rule. So Jacqueline King, you can see there, those are not her breasts, that's actually a bra that she made to look like breasts. And so she's basically saying, well, I'm clothed, so, I dare you. So again, what I saw was that relationship between technology and artists, American artists are just, they're an unruly lot and always have been, I would say. And this is dissent. This is not all that different than Thomas Paine, in its own way. So, actually, we'll get to that a little bit later, but I guess that's my answer to your question.
And if I can say from a legal perspective, that word freedom of speech and of the press, one of the perennial debates we've had throughout constitutional law history is whether various new media are encompassed within the words speech or press. So every time there's been a new medium, the Supreme Court has said, well, the First Amendment won't necessarily apply. We have to decide whether it is encompassed by the terms of the free speech clause. And the first time the court ruled on movies, when they were a new technology, the court ruled that it doesn't come within the First Amendment at all, completely unprotected. It was only the second time around, many generations later, that the court did protect films. And to this day, this is incomprehensible to my students, to this day, over-the-air broadcast, radio and TV, is deemed to be within the general ambit of the First Amendment free speech clause, but not to the same extent as other media, which is why it is still illegal to use patently offensive or indecent or profane. Those are the terms that are used. They're vague and subjective, but it is illegal to use any expression that is deemed by an enforcer to satisfy those criteria when you are over-the-air radio or TV. And to this day, when I talk about one of my very favorite John Marshall Harlan II opinions, which is truly a landmark free speech opinion called Cohen versus California, that upheld the particular facts arose out of the Vietnam era, but the holding has implications far beyond the particular case. But it's important to know that at the time, in the early 70s, the word fuck was incredibly offensive. I have to explain that to my students because now it seems so tame, but truly it was as controversial and as hated, really, I'm not exaggerating, as the N-word is today, as connoted by the fact that they would use the term the F-word. And the Supreme Court, when it was an ACLU case, when our lawyer was standing up to give his oral argument, the Chief Justice said, "Counsel, we know the facts of the case. It is not necessary for you to recite them." And thank goodness our lawyer said this case involves the right to criticize government policy, including through saying, "fuck the draft." If he had not done that, I think he would have lost the case, because he was acknowledging the fact that the word was so offensive. And it truly was, I mean, by common opinion. The Supreme Court Chief Justice told Harlan, "Well, John, when you write the opinion, you please write it. I beg you, John, please write it without putting that word." And he couldn't even get himself to say the word. But anyway, so it's a very important case. And to this day, I mean, just last week I did an over-the-air radio interview, and the case came up, and I was bleeped when I'm describing the facts of a Supreme Court case. The word is in the official United States reports, and you still can't say it over the air. Now, when the internet first hit the public and media and political radar screen in the early 1990s, it had been known to the scientific and engineering community before that. But when it came to public attention, politicians and the media and the public greeted it the way new media have been greeted throughout history, which is seeing some of us were cheering the potential liberating and empowering and equalizing potential, but more people and more officials were much more concerned about the potential dangers. So Congress did what it's done for all new media, which is to immediately pass a censorship law. That was almost nobody voted against it from either political party. Bill Clinton was president. He signed the law and defended it vigorously in court. So the case that went down in history, I'm so proud to say, as defending freedom of speech on the internet. We could not take this for granted. I have to tell my students, the world would have been extremely different if the internet had been treated as the Clinton administration and everybody else in government wanted to treat it, this second-class status similar to the broadcast media. So the case is called Reno, as in Janet Reno, Bill Clinton's Attorney General, against ACLU. And basically the government was arguing that it is such a new and dangerous medium that can reach, and you know what, who's endangered, it can reach children, and the particular expression that was feared and that was censored in the law was sexual expression, patently offensive or indecent. And that's the peculiar thing about the United States, which has such a robust free speech guarantee when it comes to libel and dissent and political opinions, hate speech. We are so much more protective than every other country. But when it comes to sexual expression, we're much more censorious than many other countries. And that still, Anthony Comstock has come and gone, but that aspect of our culture is still here.
Oh, absolutely. And, our Vice President Mike Pence is a devout evangelical, and a lot of the laws, certainly if he were president, certainly he would be looking to sign a lot of legislation that would resemble Comstock era laws. One thing I wanted to point out, and I think it's so important to drill down on distinctions between political speech and sexual speech, but also between where and when it's said. I teach at State University of New York. You know, the First Amendment applies to public institutions. You teach at New York Law School. I can say fuck, right? And I assume that I will be protected by the First Amendment. It is possible, though highly unlikely, that as a private, you know, as a professor at a private institution, the First Amendment doesn't cover speech in that vector. And that's one of the things, too, about thinking about social media. These are all private companies, Facebook, Twitter, Instagram. The Americans expect to have First Amendment rights on these social media platforms, but because these are private companies, they are not required to actually extend First Amendment rights. And that's where the expectations of the people are so paramount to making sure that we continue to have free speech rights. And the distinction between broadcast radio and television and cable, right,
Or
and the
satellite.
internet.
Yeah,
I mean,
yeah.
even if we agreed to be polite and stop saying the F word on campus streaming, it's out there. You can all go back to your computers at home and look up any number of millions of YouTube videos that are going to use much more profane speech. And so one of the things that's really interesting to me is to think about what speech do we sort of take for granted that we have freedom to express, and where does it come from? And again, understanding the legal distinctions between public and private institutions and platforms, I think, is really important.
And most people don't know that with only one exception, the Constitution only applies to the public sector and not to the private sector. So you have no First Amendment rights against a private university or against any private medium, whether it be the New York Times or Facebook. And to the contrary, they have their own First Amendment rights, which include the editorial right to decide what to publish and what not to publish. So when we won Reno versus ACLU, that was striking down a federal statute that was trying to compel the online companies to keep off certain expression. That was struck down. The government may not do that, but those companies can in turn enforce their own so-called community standards. And they've done it in ways predictably that are not at all favorable to any critics of government policy, any minorities, and including women have complained consistently about even the anti-nudity rules are apparently enforced in a way that's disproportionately negative for women. Every once in a while, there's a lot of mass media coverage of one of these incidents, which are constant, but one that got a lot of attention a couple of years ago was when that iconic photograph from the Vietnam War of the naked little girl who was running down a village road because of a napalm attack. That was taken down by Facebook because it was treated as child pornography under their, quote, standards, close quote.
And it won a Pulitzer Prize. Right. There's been a lot of, again, pushback that comes from the public about, for example, paintings of nudes. And they have really evolved their rules, and it's just like watching the history of 20th century free speech law just recycled. Like they went from the Hicklin test to now they're kind of up to the Miller test, and you know, they're just sort of realizing the same difficulties. You can't algorithm your way out of the slippery slope problem. So this is sort of the place that we find ourselves right now.
So Zuckerberg, read Amy's book. You need it.
I thought about that, Mark Zuckerberg.
Yeah.
I'm here at FIT.
Nadine, I wanted to ask you, why do you think the terms indecency and hate speech are so problematic?
They are inherently subjective terms, right? One person's hate speech is somebody else's cherished speech. If you pay attention to how that term is slung about, and one can say the same thing for indecency, but I'll start with hate speech because I've written about that more recently. If you start paying attention, you will see the term used promiscuously by anybody to demonize or stigmatize whatever expression they personally hate. And I've read every hate speech law in the world that has either been enacted or proposed, and it's an inescapably vague concept. So typical language is speech that conveys disparaging or demeaning or degrading or dehumanizing views on various bases. And under those so-called standards, to take some examples, in the United States, there has been recent examples. There have been serious calls to treat Black Lives Matter activism and advocacy as hate speech allegedly against white people, against police officers. Last summer, when 5 police officers were assassinated in Dallas, government officials in Texas and elsewhere actually called for punishing Black Lives Matter movement leaders as committing hate crimes. Correspondingly, some people, including some Black Lives Matter activists, have said the phrase Blue Lives Matter is hate speech because they see it as denigrating the seriousness of equality and dignity for Black people. And the phrase all lives matter has been treated as hate speech on a number of campuses. Most chillingly to me, on a number of campuses, the phrase free speech has been attacked as hate speech. And I understand the plausibility because people see that white supremacists have what they, from their perspective, hidden behind the mantra of free speech. So there's a ring of plausibility to all of these. So I would say let each person decide for himself or herself what idea they consider to be so hateful or hated that they choose not to listen to it, or they choose to respond to it, or they choose to educate against it. But we cannot possibly delegate to the government, or I would contend powerful private sector entities such as the social media companies, these inherently discretionary decisions. We can predict that over time, disproportionately, that subjective power is going to be wielded in a way that undermines the speech and the rights of those who have traditionally been excluded, discriminated against, and marginalized. And when you look at the history of the enforcement of laws against sexual expression, against hate speech, against indecency, there is consistently a pattern of disproportionately enforcing them against precisely those people who are resisting the status quo and protesting and trying to seek progressive reform and equality.
Would you say you see the same thing happening, especially with the word indecency throughout the earlier period?
Oh, yeah, absolutely. And one of the things that was kind of interesting was when they were drafting the Comstock Act, there had been some very ineffectual anti-obscenity laws at the state and federal level that really nobody had even tried to enforce. But in order to make this stronger, they just kept adding more adjectives. So it's like they're looking up synonyms, you know, and like throwing them in. So lewd and lascivious and indecent and prurient, and as though all those adjectives are equally vague, and just having more of them didn't make the law less vague. But that was definitely the way, that they saw it at the time. And that interests me as a writer, and of course not having a law degree. I've never actually written law, although on my school board I wrote lots of motions and came to see the power of words themselves and the importance of how words are written. And I think getting back to the means we have for dissent, which is so important to preserve at this moment in time, especially as our country is going through a lot of upheaval. And I keep thinking about the keel to right the boat. Like the First Amendment, our right to dissent and to protest has been the keel over time that has enabled us to right the boat, to move away from authoritarian kind of overextension of executive power, and so preserving the bones of our ability to dissent is so important, and that language in the First Amendment is so open. It is so broad. There's really not exceptions in the First Amendment, and then of course there need to be some. Obviously, there is some speech that is such a I know we don't use clear and present danger anymore, but that is
It's the concept. I mean, it's often called the emergency exception now. And so you have to show that in a particular context, the speech directly causes certain specific, imminent, serious harm that can't be prevented in any other way. And you know, most people get it wrong. They purport to be quoting Oliver Wendell Holmes saying, you can't shout fire in a crowded theater, but if the theater is on fire, you want people to shout it, right? So it's very important to put the word falsely in there, and that really underscores the functional concept of unprotected speech. If the theater's on fire and you shout fire, you're saving lives or potentially saving lives, so that should be protected. But if it's false and it threatens a stampede that would endanger people imminently, it's should be punished. If there's a more, again, as I was saying in the bad old days, we had a much more loose standard, this general notion of a harmful tendency speech that might potentially, a much looser connection between speech and potential harm. And again, with the sole exception of obscenity to this day can still be prosecuted and punished.
And the concept of obscenity used to be any speech about sexual health.
Yeah.
Which once we have that carve out, I mean, what's to keep a really right-wing evangelical administration from trying once again to impose that standard and to see birth control and abortion and discussion about, you know, where you could get birth control or abortion as obscene speech.
Or LGBT sexuality. There was just an
Absolutely,
incident I read about today where some fundamentalists went to a library and took out all the books that were aimed at young adults or children that had any sexual minority or gender identity issues and burned them all.
Yeah, check them out and burn them. And right now, that library, there was a Kickstarter, that library is going to get, I'm guessing, like 50 times more LGBTQ-friendly books than it ever had. This is in Iowa. But again, we rely on the fact that, and the ALA is fantastic. Yay, librarians, the American Librarian Association, the American Library Association is fantastic. But we rely on the fact that that man will be, you know, criminally prosecuted for burning books, as opposed to cheered and, you know, celebrated and the librarians put in jail for having the books on display. That's where, again, we the people need to understand the importance of advocating for free speech, and even for speech we don't like. That's the hard part, is to accept that my free speech rights are contingent on the free speech rights of people to say things that I profoundly disagree with.
I also want to point out that in one of the main threads of your book is that it doesn't work. So even if you are a Mike Pence or a Comstock, don't censor, because the backlash is going to overwhelm your attempt to censor.
Right. And
we've got a much dirtier world today because Comstock tried to make us less dirty.
Yeah, and I think that gets to sort of the topic of, you know, what do we worry about going forward? And I've been collecting these headlines, and I made sort of a headline cloud here. But one of the things that worries me is that I hear people giving up on free speech, that they've really decided that it's free speech that is the cause of all of our problems. And I think actually it really ramped up after Citizens United, because it was seen that sort of the conservative movement had, you know, declared commercial speech.
Can you tell the audience a little bit more about what Citizens United is?
I would actually love if
Or
Nadine
Nadine.
would do.
Well, yeah, I actually think that case was decided correctly, so that's a very provocative, controversial statement. And most people would say that was a decision, so this is a little bit beside the point here, but I'll take the opportunity. It was a case that most people describe as allowing big, bad, evil, for-profit corporations to, completely corrupt the political system. Actually, the law that the Supreme Court struck down in that case, which is almost never described accurately, prohibited all corporations, including not-for-profit corporations, and all labor unions from spending our own money. And I say our own because the ACLU is a not-for-profit corporation, as is Planned Parenthood, as is just about every organization that we know and love and support, including many museums and including art museums, to spend our own money, not to contribute to the coffers of candidates, but to purchase advertisements on issues that mentioned the name of somebody who was running for federal office. At that time, the so-called Patriot Act had just been passed in the aftermath of 9/11, which was an unprecedented extermination of privacy and free speech and due process rights for everybody in this country, but particularly for young Muslim immigrants, male immigrants from certain countries. So the ACLU and the American Library Association were crusading with us against many provisions in the Patriot Act. Library patrons' records were overturned, were subject to disclosure to the government. And it became a crime for the ACLU to call on then President Bush to repeal the Patriot Act, or call on any member of Congress who was running for office to vote to repeal the Patriot Act, even though in the period running up to elections is when people pay attention to issues. My organization, the ACLU, by our own corporate charter, never takes a position for or against a candidate, but we call on candidates to take positions on civil liberties issues. So it would have been, I would have faced a 5-year prison term if I had done what we had done before the law was passed and advocated for civil liberties positions. And most people are just shocked to know that's what the law did. The Supreme Court opinion, Anthony Kennedy's majority opinion, actually used the ACLU as an example, and he gave another example from the Sierra Club, which was also prohibited from giving pro-environmental messages. And when I explained all this the first time to my husband, he said, people don't understand that that's what this case was about. He said, you ought to bring a test case, because the Supreme Court had initially upheld the law, but had said, and then it had said, but we might in a particular case strike it down. And so before Citizens United, when the Supreme Court reversed, the upholding of the law, my husband said, you ought to bring a test case, by having you go on the air for the ACLU and tell President Bush to repeal the Patriot Act, and then you'll be prosecuted. And I said, honey, I could face a 5-year prison term. Is that a price worth paying for freedom of speech? And he said, yes. So, and getting into this, and there are enormous problems with our campaign finance system. I and the ACLU are the first to acknowledge it. But as so often happens, the censorship law, and that was a censorship law, prohibiting people from spending money to promulgate a message, means that the message is not going to be distributed as widely. And the reason for passing the law is always a strong one, and the purpose is at least 99% of the time a purpose that I share. I share the goal of improving the financing of our political system for a whole host of reasons. I certainly share the goal of empowering women and preventing violence and discrimination against women, which was the goal of the feminist anti-pornography movement. I certainly share all of the goals of people who are supporting hate speech laws, including on college campuses. I fervently believe and work for equality and dignity and diversity and inclusivity and societal harmony and individual mental well-being. But in all of these situations, well-intended as the censorship is, it ends up doing more harm than good, specifically for all of those causes that we deeply care about. And the fact that I just love the flourishing of campus activism that we've seen in the last few years. It brings me back memories of when I was a campus activist in the late 60s and early 70s, and in the intervening period, students have been mostly apathetic and not at all interested. As surveys show, they weren't interested in even reading or learning about the news, let alone making it. So it's just thrilling to me that we have this huge movement of social justice activism on campus. But at the same time, I've been very concerned about surveys and anecdotes showing that students and many others believe that robust freedom of speech is their enemy rather than what I know it to be, which is the time-tested and essential ally. So that's why I wrote my book, to try to persuade people of that perspective.
So if there are students out there who agree with you already and want to become free speech activists, what should they do to move forward in a career direction? Where should they be going to school? What should they major in? What sort of networking should they be doing? How can they become more like you?
That's very sweet.
Wow.
Well, it seems to be, I want to say inherent in all of us, including very young people, to have the self-confidence to raise our voices, to make a difference. I mean, look at the young students who were so articulate in the wake of the Parkland school shootings, and were speaking to local audiences and national audiences, and they hadn't even been schooled in any of these, either speaking or organizing or constitutional law. So I think parents and teachers and others have to constantly tell young people, and old people for that matter, that your voice really does make a difference. And that's one thing I can say as an activist. A lot of people are skeptical, and I understand with gerrymandering, you can say my vote doesn't count, why should I vote? But we know it does make a difference. And thanks to social media, here's one of the positive things about it. Voices are amplified in ways that never would have been possible with the traditional media. I mean, we would not have had a Black Lives Matter activist movement without social media. We would not have had a Me Too movement without social media. And I'm very, very concerned about the so-called digital divide, and I know that resources, including access to technology and educational wherewithal to make the most effective use of technology, are still unequally distributed in our society, with racial disparities among others. But thank goodness those disparities are much less glaring than they were with respect to, the much more expensive prior media, where A.J. Liebling famously said at the beginning of the 20th century, freedom of the press belongs to he who's wealthy enough to own a printing press. Now you really only need a laptop and a basic education.
In the conclusion of my book, I talk about the moment that the YMCA kicked out the Committee on Obscene Literature that was paying Comstock to go around New York and round up defendants and put them in jail. And because they really wanted to focus on building libraries and gymnasiums and offering healthful entertainments. And when you look at the history of the New York Society for the Suppression of Vice, I'm guessing a lot of you've never heard of it, or maybe all of you never heard of it, but you've all heard of the YMCA. So which is the more sustainable path that has power in society? And I really believe it's to choose the path of making a positive contribution, so that thing, don't boo, vote. I mean, think about going and yelling at people eating in restaurants. Like, strategically, it really is not going to help the cause. But on the other hand, going out and organizing and getting people to the polls and raising money for candidates that you like, and speaking up at your local town hall meetings and your school board meetings and getting involved, that all of that really does have the potential to kind of strengthen our democracy. So I wholeheartedly agree with you. And just getting back to my thoughts about Citizens United, and I've had this explained to me many times, is that you have to think about where is the problem. And the problem is, why do people have billions of dollars, and why do corporations have billions of dollars that they can just spend tens or hundreds of millions of dollars trying to influence the political process? The problem is in the tax code. The problem is in lax tax enforcement. The problem is in corruption, and that weakening our free speech protections is a very dangerous path to go down to think about solving that sort of fundamental problem. And then the other thing is, just look at what's happening with donations. Donations to the ACLU have tripled. Is that correct?
Oh, much more than that. I'd say more.
Since 2016.
Much more.
Right. So there are, like, always to think, what are correctives to the problem? Look at all the different possible correctives to the problem we've identified. And let's not choose the one that is limiting our ability to dissent. Let's choose the one that's actually going to preserve our civil liberties while also, contributing to solving the problem.
So we're about to open it up to questions. There's a couple of mics up there if people want to start moving towards them. But I did want to ask you both one more question. Both of your books have been out for a little bit now. What's the most surprising reaction that you've gotten to the book?
Well, I have been pleasantly surprised at the number of people who have told me that they were absolutely opposed to my ideas based just on the title, and then for some reason were forced to read it and completely changed their minds. And it happened just yesterday. I was interviewed for a new podcast by the American Booksellers Foundation for Free Expression, and the head of that organization is about my age, a baby boomer, and he deliberately assigned the podcast to a millennial who proudly said that she was speaking for millennials, and public opinion surveys do show that a majority of them support censoring hate speech for the right motives. They were wonderfully committed to equality and dignity, and they were raised to respect people who were others, and they were raised to oppose bullying. So again, I totally support the goals that they think are going to be served. So she had to read my book, and she thought she knew that she would oppose my ideas, and she became, you really saw the zeal of the convert, and this is not the first time this has happened, that she became so excited and so converted that she, said that she goes around talking to all of her friends, you have to read this, and getting into arguments and discussions with them. And when it came time to name the podcast, see, I am advocating resisting hatred. That's the main theme of my book, but doing it with counter speech, with more speech, not less. And this young woman lobbied for the name of the whole podcast series to be Counter Speak. And it was sort of like a verb, counter speak. Yeah. And so she really got the message. Yeah. And so I continue to have that kind of pleasant surprise.
That's great. Amy?
Well, I'm surprised that more people haven't commented on the very smutty pictures in my book, because I illustrate a lot of the obscenity, a lot of the evidence in obscenity trials of the 19th century. And I kind of thought, like Comstock's defendants, that this would be good to get a little bit of, controversy going about this picture. But mostly people are like, yeah, whatever. And I spoke at a wonderful history book festival in Lewes, Delaware, and the head of the Delaware Humanities Council said, I love your book. I want you to be to do the book club for the Delaware Humanities Council, and they invite members of the general public, and they order a whole bunch of books for the library. And of course, this is like an author's dream. It's like, of course, I'll talk to anybody who's reading my book. That's great. And I said, but you looked at the pictures, right? And she said, yeah. And I said, so you're not worried that anybody would be offended? And she said, well, they can just grow themselves up. Like, yay.
That's great. Is there anybody in the audience who would like to ask a question?
And if anybody wants to hear commentary about any of these free speech developments,
And I'll tell you, I'll keep asking questions if no one else has any, but it looks like we might have one or two here. Can you go to the mics over there, or I can actually bring you a mic if you prefer? Great, please.
Well, I'm a political activist and a protest artist, and I find that despite the corporate media being very controlled, they're all too willing to publish radical protest art for the lack of accountability. They can't get fired. But they can't say things with words. The media is very top-down. I'd read that 90% of our content is produced by 6 huge corporations. So we really don't have free speech in terms of the mainstream, the corporate news. But on that score, recently 800 websites, both left and right, were taken down by Facebook, and their Twitter accounts were also removed. And they took them down on the advice of something called the Atlantic Council, which is the think tank funded by NATO and certain Middle East dictatorships. So I just wonder if you'd comment on that reality.
Well, I wasn't aware of that particular situation, but I certainly have followed many situations where Facebook and the other large companies, let's face it, they're businesses. They are concerned about the bottom line, economic pressures and factors. So I don't know the exact story behind that particular pressure, but Google recently, after having resisted and pulled out of the Chinese market, now is openly saying that it's going back in, even though it knows that therefore it's going to be part of the great Chinese firewall, and many Google employees are protesting. But I think that I'm not giving up hope, because as consumers, we could raise our voices to put consumer type pressure on these companies to exercise their power in a way that's friendly toward free speech and democracy. I assume that when Nike recently made the decision to use Colin Kaepernick as a spokesperson, or to laud him, that I assume they were not committing financial sacrifice. I assume that they made a strategic judgment that, at least in the long run, that would be good for business. So if more of us raised our voices in our capacity as consumers to put pressure on, we're not going to use, it seems so unrealistic, I must admit. I'm not going to use Google because they're going into China.
Right.
The only other alternative would be some kind of government regulation, and that makes me extremely nervous. I don't like the way government has used its power to regulate the content of traditional media. The only kind of regulation that I think might be acceptable from a civil liberties perspective is antitrust. I mean, right, if we had a fully functioning economic marketplace as well as marketplace of ideas, then there would be room for new companies to enter the marketplace that would be more free speech friendly. So we wouldn't be forced to use Google. We could use another company that provided the same services and wasn't doing business with China. But I understand that the market is now so structured in such a way that it's virtually impossible for a new company to enter in, and that's why some antitrust experts are saying that we ought to do what was done to Ma Bell a couple generations ago and break these up and increase competition.
Yeah, a lot of people have been talking about the hipster antitrust movement, which
I didn't
is
know that.
oh yes,
Thank you.
it's a new term that
Thank you.
the idea is that we need to go back to Brandeis and say
Yeah.
that not the only damage is higher prices to
Yeah.
consumers. There
Yeah.
are other damages
Well,
as well.
so I hadn't heard
Yeah.
that term, but what's really exciting to me as a law professor is one of the chief theoreticians who went back and dug around and wrote an article in the Harvard Law Review about these old theories was a law student while she was doing it. And she's now been hired by the FCC. So this is a perfect example of how young people should feel emboldened and empowered.
Yeah.
You know, as persuasive as your ideas are, they can have power regardless of your age or your stature.
And as a historian, you know, we are in the new Gilded Age. I mean, it's the new Jim Crow, which is also the new Gilded Age. And that was, you know, when the progressive era happened. And I certainly think that's one of the possibilities, that we would end up with a very progressive, you know, not necessarily all of a sudden in this election, but maybe over a couple of cycles, we would be in a position where that kind of legislation actually is imaginable. I mean, now it is so unimaginable in terms of who pays off politicians and, you know, where the money comes from, and the mergers that have been taking place. But we can do it, you know, we've done it before.
I think there were some other questions from people who maybe didn't want to get up. Is there anybody who I can walk to with a microphone? Do my best impression of Phil Donahue? You got a mic over here. Go ahead.
I arrived late, so I apologize if you've already touched upon this. Within the framework you've discussed, how do you view situations such as the violence inspired by the Pizzagate claims of children being held and trafficked in the pizza place in D.C., where someone was inspired to go with a gun and shoot, or the Sandy Hook parents who it seems have had listeners to Alex Jones weaponized and have had themselves targeted and harassed, and their grief exacerbated by these people who claim that they are actors and whatnot. I mean,
So if the Sandy Hook parents is a distinguishable situation because they are making a claim for defamation, which is, you know, a specific example of speech that directly causes particular imminent serious harm, namely it is false, intentionally false speech that is defamatory to their reputations and damages their reputations in demonstrable ways that cause demonstrable, tangible injury. So I completely agree with the court that recently rejected an attempt by Alex Jones to dismiss that defamation claim on First Amendment grounds. Now, I will say that there should be limits to defamation actions, and ironically, these are the limits that Donald Trump wants to get rid of. Remember, he kept saying when he was a candidate, and he said since he got elected, that defamation, it should be easier for public officials and public figures to win defamation cases. I think that would be extremely dangerous because we, the people, again, to quote the opening words in the Constitution, we wield sovereign power, and if we are going to hold those we elect accountable to us, we have to be free to criticize them in very strong terms without having to worry that something we say might be slightly inaccurate and therefore could cause us to be subject to enormous damages. And again, I'll go back to a theme that you may have missed. At the very beginning, I talked about how all of the strong free speech cases, or most of them, came in the context of the civil rights movement, and including the limitation on defamation actions against public officials. A very famous case called New York Times versus Sullivan. If the Supreme Court had not strictly limited defamation actions against government officials, the NAACP and individuals who were involved in the civil rights movement would have been bankrupted, because that was one of the strategies that local Southern officials were using to try to silence those protesters. Now, in terms of particular individuals who say that they were instigated or may well have been instigated by some controversial expression or any expression to commit a violent act, That is too loose a standard in a free society. Think of examples of people who have been instigated to commit heinous acts of murder and mass violence by things that they have read or heard or that other people have said to them. The book that has been most often blamed for the most harm, including against women and children, is the Bible. And there are many examples from popular culture as well, where people have seen movies that had violent themes and committed copycat acts. So it can't be the fact that somebody heard some speech at Pizzagate and then goes and commits a crime. I think the Supreme Court is exactly right when it says, you know, it has to be intentional on the part of the speaker. The speaker has to intend to incite imminent violence or to instill a reasonable fear. And sometimes the factual situation is murky and reasonable people can disagree as to whether the standard is satisfied, but I think it does have to be that strict a standard. There actually are a couple cases that are pending now against Donald Trump because during some of his campaign rallies, he said things that allegedly instigated, incited, intentionally people, his supporters, to commit violent acts against protesters at the rallies. And I don't know enough about the factual details myself, but the judges who have ruled in these cases have said in a couple instances there is enough evidence that a reasonable jury could find that that demanding standard, but not impossible standard, was actually satisfied. I think in some cases he said something about the good old days when people used to be beaten up, or he said, I'll pay your lawyer's fees, and things like that. So it doesn't have to be express as long as the message is conveyed. It can be conveyed in dog whistle fashion. Yeah.
What I was going to ask before was the same thing that he recently said, oh, that's my guy, about the guy who body slammed the journalist. And you're saying that there have been some actions brought against him, but that sounds to me like incitement, like free reign to attack journalists and hurt and injure. And we'll look at what's happening now with Khashoggi. And so these actions that you talk about, what's happening with them? I mean, you say actions have been brought, and it might be satisfy the demands.
They're still pending in the courts, and so that means that, and that's true for the defamation action against Alex Jones as well. So that means it goes to a jury, and the jury gets to decide, do the facts in this particular situation actually satisfy that standard? But the example, so then it would have to be legal damages, because so he would have to pay pay money, which of course is not much of a disincentive for somebody who's supposedly so wealthy. There were also a couple of jurisdictions where there was actually a criminal investigation or two. And to the best of my knowledge, Laura, both of those have been dropped, that the local law enforcement officials thought that the standard for criminal prosecution was not satisfied. Now, the example that you give, I mean, the deplorable attacks on journalists, even saying that the press is the enemy of the people, these are deplorable statements. And I have absolutely no doubt that they fuel attitudes that lead to hostility and distrust, which has all kinds of negative consequences, including eroding the effective functioning of what's often been called the fourth branch of our government. But that cannot, so that's a justification for criticizing, for counter-speaking, as many have done, including many newspapers. I think in the fall there was a campaign, and newspapers all over the country, big and small, had editorials talking about, pushing back against that demonization of the press. But that kind of loose language cannot possibly be the basis for either criminal punishment or civil damages, or it is definitely going to mute the voices of government critics. And again, the cases that came up with this strong protection all came up in the civil rights movement, when very strong inflammatory language was used against government officials. One of the major cases, eerily resonant today, but went back to the early 60s, and there was a group of African American men who were meeting in Washington, D.C. to protest police abuse and unjustified violence against young men of color. And they were in their conversation, this was while the Vietnam draft was going on, and one of the young men who was very angry about, police abuse and about the war, and he said, if they draft me and give me a gun, the first man I am going to get in my sights is LBJ, referring to the President of the United States at the time. And that he was actually convicted for threatening and for inciting. And fortunately, the Supreme Court overturned that. And I could give similar examples coming from other really strong language by civil rights leaders, using language that was even, so one involved a boycott that the NAACP was having in Mississippi. I'm sorry, either Alabama or Mississippi, I keep getting them mixed up. That's unforgivable, but, they were boycotting white merchants who discriminated on the basis of race, and the leader of the NAACP said, we catch anybody breaking that boycott, we're going to break their necks, we're going to break their legs, and some violence actually was committed against people who broke the boycott. And again, the NAACP would have been bankrupted if the state court judgments against them had been upheld, but the Supreme Court overturned it. It said, given our democracy, it's just really important that we err in favor of giving too much protection to even really strong, even speech that's advocating violence, as long as it is not intentionally inciting imminent violence. It does more harm than good to a democracy and to justice and all of these causes if we give government more power to punish speech.
That said, we really need to strengthen education. And I think there's been a very strategic and very purposeful campaign against education at the K-12 level in many states, and against higher education.
Oh, for sure.
For sure, because the only way for, authoritarian rule to really flourish here is to devalue truth and expertise, and the kind of, critical thinking that people can exercise in listening to that kind of speech and saying, oh, I'm not voting for somebody who threatens to beat up the press. I mean, the way our government is supposed to work is that kind of behavior is not rewarded with, high office. So, obviously, the solution to gerrymandering, is at the ballot box, and the solution to, restoring some norms is to vote for people who uphold norms of, a speech that we consider to be civil and productive, and while not saying that speech that is coarse and confrontational and full of dissent is unlawful. But I think that again, it's always this issue of looking at how the speech is being produced, but why is it powerful? Yeah. And often the problem is not the speech itself. The problem is, in this case, that a lot of people think it's okay. So the problem is in culture and not as much in law, from my perspective.
Yeah, it's very distressing, and I mean this not in a partisan manner at all. But I was very distressed at the recent statements by Hillary Clinton and not Eric Schneiderman.
Holder?
Eric Holder, basically saying we should stoop to their level.
Oh, yeah,
Because I
when they
always,
go
I mean,
low.
I so admire the rhetoric of Barack and Michelle Obama. When they go low, we go
Yeah.
high. But there seems to be some recognition that, or belief that that's not effective anymore in our culture.
Right, and
And
that
there
worries
may
me.
be some gender differences too. I mean, look at how Brett Kavanaugh, I think, changed the outcome of those hearings by rhetoric that I think would have undone a female if
Oh,
she had used similar
absolutely.
language.
It was immature. It was an immature rant. You would have, these are very unsettling times, and yet, I really believe again the keel to the boat is our right to dissent, and we need to preserve it in order to have a kind of more hopeful, outlook on the future.
I think we have time for one more question.
It's about the right to vote. Ralph Nader recently said that running for office is a free speech First Amendment right, which I thought was interesting. Every 4 years, most people's only engagement, every 4 years they get all into the Super Bowl of the presidential election. What is not and will not and has not been discussed, though it's pretty well known, is that since computers came in, our elections have been counted in secret with privately owned proprietary software
Yeah.
by a small handful of corporations with convicted felons on their boards. Bernie won all 7 states where they hand count paper ballots with witnesses. Bernie won 12 of 14 caucus states in a row by a spread of 36.6% because in those states they hand count paper ballots with witnesses. Hillary won 23 states where they have computers, and in 10 of those states she won outside the exit polling data margin of error used by the UN and the State Department to validate or invalidate foreign elections. In 10 of those crucial states, she won outside the 2% margin of error. It was off by 11.8% in New York State. And what they do in this country is they ignore the exit polling data. By the next day, they've adjusted it to match the computer totals. So I would suggest we're living in a coup state, and that issue, which no one will touch, should be front and center. We don't vote anymore.
Well, I thank you. I don't know if I should thank you for that depressing account, but thank you for that information. I'll definitely look into it. I'm certainly aware of so many problems with our electoral system and voter suppression that is of various types that is disproportionately disenfranchising people of color and poor people and young people and people with disabilities and students. And one of the points I make in all of my talks about my book is, I'm so concerned about the problems of discrimination and inequality, and I get frustrated about the frustration, the focus on language, because to me that's a superficial manifestation of deep-seated problems that have to do with attitudes, which are going to be changed not through censorship but through education. And that we also have so many flagrant problems of actual discriminatory conduct and discriminatory violence. And I always use discriminatory disenfranchisement as an example, and through voter suppression, and you've now given, the electoral college system and gerrymandering. And by the way, it wasn't just Ralph Nader, but a number of us argued, including the ACLU, in the gerrymandering case in a hope of persuading Justice Kennedy, who seemed to be the swing vote, that in addition to the traditional equality arguments against gerrymandering, which have never gotten a majority vote, that Kennedy, being such a supporter of free speech, we thought we could make a very strong argument that the most important exercise of your freedom of speech in a democracy is through the franchise and people's voices are disproportionately chilled if their votes don't count. He passed on that issue, but I think it's a very persuasive one.
And I would just say, down ballot matters. It matters who your state House representatives are and your state senators. It matters who your Attorney General and your Secretary of State are. It matters who your governor is. I mean, this is the answer to pretty much everything, is to hold representatives accountable. We always face new challenges and inclusive threats and new technologies, and election security right now is a really big threat. We need to vote people into office who care about the threat and who care about democracy. I think that's really the biggest threat that we face right now, is that there, is to allow an idea to take hold that we can succeed by reducing our civil liberties and by reducing, democracy. And it's happening all over the world. These concepts are under threat all over the world. They go along, and they can really only thrive. Those ideas can only thrive with an attack on education and an attack on the truth and an attack on investigative journalists. And we need to resist all of that at the ballot box and hold our elected representatives accountable.
Thank you. I think we're out of time. Yes, NJ? Oh, yes.
Valerian.
Let me bring you a mic. Hold on.
Thank you. I think this question is a little bit more directed to Ms. Strawson. And I kind of wrote it down to just gather my thoughts, and has to do with the topic that we had just discussed. As someone who studies law, what opinions or solutions do you offer to Native Americans whose voices are who might not be considered, or who have been censored continuously, especially in voter rights? For example, that they cannot vote because their mailing addresses are reserves and it's not considered. So in a sense of what opinions or solutions might you have for them who face continuously?
It's a horrible problem, and when the Voting Rights Act was most recently re-extended, I had the privilege of testifying before the Senate in support of extending it, and based on the work of the ACLU Voting Rights Project, including on behalf of Native Americans in particular. I remember in the Dakotas were a real issue even back then. And that was all well and good. There was bipartisan support for extending that law. It used to have real teeth in it at that point, and it was a Republican president who signed it, George W. Bush. But then the United States Supreme Court, quote, interpreted the law, really misinterpreted, in a way that took out the really strong enforcement provision, which said that anytime there was a change in the voting laws in a state that had a record of discriminating in voting, which certainly included all the states with native lands, reservations, including the Dakotas, they used to have to get prior approval from the Department of Justice. And the Supreme Court basically, with a 5-4 vote, saying, times have changed. We used to have discrimination. We don't anymore. And by the way, that's one of the reasons one of many reasons why I think more harm than good is done by suppressing hateful and discriminatory speech, because it's easier for people to say, we don't have discrimination problems anymore. And that leads to real adverse consequences in these kinds of situations. So now these states can just go ahead and pass these new laws, including the one that requires you to have a street address, which is against the Native American traditions, and we no longer have a remedy under the Voting Rights Act. So that means that there is an attempt to have a policy fix. So Native Americans and others are using some system, as I understand it, to convert the physical place where people are living to attach some address to it. And they're working very hard to try to do that, but under enormous time pressure, without very many resources to do it, and with a hostile state government that no doubt is going to continue to throw up obstacles. So, you know, one avenue of recourse is shut, we try to use another one, but ultimately it goes back to a point that Amy has stressed, including in her latest remarks, and that I quoted Zechariah Chafee. Ultimately, the power is with we the people, and we ultimately have to vote out those who are using their political power to suppress rights. And I am optimistic about the future, because when you look at opinion polls of young people, their attitudes on these issues are very supportive. Unfortunately, they're the ones that don't vote as much, especially in midterm elections. So I mean, while you're raising that issue, that's so helpful, because it shows that even if you think you can't affect who's going to be elected to Senate, you might be able to affect who's elected to Secretary of State or to some local official who has control over these issues that ultimately, aggregately, have national repercussions.
Thank you.
Well, thank you, everyone. But I just want to make mention that our two authors' copies of their books are for sale up in the top in the back. So if someone would like to read more or purchase one for a friend, they are here for sale. And please join me in thanking our authors and our moderator for an amazing evening. Thank you all for coming, and have a safe trip home. Good night.
Thank you.